our takeaway from the convention and our reading of Article 12 is that it reflects what our starting points were from the very beginning, which is that this right to legal capacity is one that all adults, regardless of intellectual capacity or decision-making ability, can enjoy, because it's about the power to direct your own life. Now, how people are going to be able to direct their own life is going to vary among us, and it's going to vary through our own lifetimes. And what we've really pushed in our work is that for some people who might be seen to have profound intellectual disabilities, if legal capacity is not about decision-making ability, they get to be included. Because really it's about, do the rest of us recognize that they have power to direct their own lives and provide them the assistance and support to do that. And in those cases, I think that the stage that we're at now in terms of implementation in different parts of the world is the challenge and the trouble that many stakeholders are having are in imagining what that looks like when it comes to a person with a profound intellectual disability. And the idea, I think people can get as far as, for people with intellectual disabilities who can express for themselves and may need some assistance in plain language or understanding, we get it. And that's largely what this kind of proposals and schemes are being designed to recognize and support right now. But for people with more profound intellectual disabilities, it's really recognizing that their expressions of their will and intention is the basis on which their power can be recognized. The dilemma is, and we've known this from the very early days of imagining this, and you were involved in it earlier than I was. The challenge is that to make that expression of will count as the basis for entering those legal relationships, you need someone who can understand that, right? So really, for those people, the kind of test is, do you have at least one person in your life who can interpret your gestures and expressions as your will and be able to give an account of that over time, sufficient to ground you as a person to whom commitments and obligations can be attached, right? Which is the basis of legal relationships. And that piece is what I think that's the biggest challenge we're facing, is that for the judges, for the legal profession, for political leaders and policymakers to say, right, that person actually has power, and even though the only way that that our attaching obligations to that person is going to rest on the interpretations provided by this one other person or two other people who constitute that person's network, that feels like too vulnerable or not valid enough. And I think frankly, that's what we have to confront, that the interpretations that loved ones can provide of someone's gestures and expressions, that those are valid, that those count, that those matter, that those are sufficient as a basis to recognize a person's authority. That's the challenge we're facing. I think it's a completely reasonable framework for recognizing someone's capacity, because really none of us have the capacity to understand all the implications of all the agreements that are made and entered into that enable us to do things in our lives, right? There's lights going on in this room. There's a camera running. There was an elevator that brought me up to this floor so that I could do this. There's so many actors involved in making this event, this small little event, happen. None of us have the cognitive ability to understand all those transactions that made this moment possible. I think there was a real hope coming out of the convention that this understanding that we could validate, because that's the biggest challenge we're facing, that we could validate this interpretive work of personal support networks and people who can provide that interpretation of someone with a profound intellectual disability. I think we were hoping that we could create legal frameworks, statutory frameworks, that would validate the authority, the interpretive authority of those persons sooner than I'm feeling we can, that ultimately we can. We're supporting initiatives right now in Colombia, in Zambia, and in Bulgaria for reform of their guardianship systems in light of Article 12. Bulgaria is very interesting because in their legal system, the convention is automatically domesticated, so it automatically becomes domestic law. Whereas in Canada, the convention is used interpretively in jurisprudence, but it's not automatically domestic law. In Bulgaria it is, and we've been working with a group of lawyers there, as well as a parent association, people with intellectual disabilities, as well as mental health consumers. And they've made huge progress on the political side and the community side, and we've been supporting the development of pilot projects for supported decision-making and the building of support networks. And those on the ground, the Parent Association, this group of nonprofit lawyers, totally get it. And it's growing at a community level at a phenomenal pace. They also then were able to get through some important litigation, commitment at a political level to create a statutory framework for supported decision-making and have a draft law that is being considered and would be the most progressive law in the world if it were implemented. I was at an event where the law was being shared with judges, had come together at a national conference. And it was there that it was absolutely pushed. The judicial community just couldn't get it. Because the whole idea that a legal agent is one who has certain cognitive abilities, meets a cognitive threshold of capacity, is just so embedded in the ways we look at each other, in the ways we think about the law, in the ways we organize our personal relationships, that the resistance, the pushback was immense. So we're at a stage, I think, where there's a much broader community of people who recognize what this looks like in people's lives, as the Parent Association did, and as people in British Columbia developed, starting back in the 70s. But getting the legal profession, the judiciary, the ministries of justice and the attorney generals to really embed this in legal systems is one that's I'm hoping if we could find some early wins on this that others could build upon, that would hold great promise. But I think this process of transformation is going to take some more time. And I think the more that we can do this in practice, support the building of relationships around people, demonstrate that people can have others in their lives who can in fact interpret them in ways that help make sense of their lives to others in the community, demonstrate that it's possible, then we'll be asking the law to recognize what people already do.